All right, thank you everyone for coming out to an awesome event tonight. It's going to be a great discussion on the role of a judge with Judge Corey Mays over here. Nice background. And
Thank
then,
you. Thank you. Couldn't find a Federalist Society background, so I picked this one instead.
and so we have our amazing guest today. Remember to put your questions in the chat using the Q&A function at the bottom. We'll definitely have a Q&A phase at the end. So without further ado, let me introduce our guest to you all tonight. So Judge Corey L. Mays currently serves as a United States District Judge of the Northern District of Alabama. He was nominated to the Federal Judicial Service by President Trump in May 2018 and confirmed by the U.S. Senate on June 18, 2019. Judge Mays earned his Bachelor of Arts summa cum laude from Auburn University and his Juris Doctor cum laude from the Georgetown University Law Center from 2003 to 2008. Judge Mays specialized in criminal prosecution as an assistant attorney general in the Office of the Attorney General of Alabama. Judge Mays then served as a Solicitor General of Alabama from 2008 to 2011, during which he argued 3 cases in the Supreme Court of the United States and won 3 Best Brief Awards from the National Association of Attorney General. From 2011 to 2019, during Judge Mays' tenure as a Special Deputy Attorney General of Alabama, he specialized in civil litigation and was involved in numerous complex civil matters during the 2010 oil spill in the Gulf of Mexico and the ongoing opioid crisis. So if we were in person, I would ask for a round of applause, but we're not. So we'll go to the next one. And moderating this discussion is Professor John Hasnas, our very own. Professor Hasnas is a professor of ethics at Georgetown's McDonough School of Business and professor of law by courtesy at Georgetown Law. He's also an executive director of the Georgetown Institute for the Study of Markets and Ethics. And as always, the views expressed tonight are the views of the speakers explicitly and not those of the Federal Society. If you want to take it, Professor Hasnas.
Okay, thanks very much. And let me welcome Judge Mays back virtually to his alma mater since he graduated from Georgetown Law School. I think everybody appreciates you taking the time to discuss the role of a federal judge tonight. And we have some time to have a conversation, so we can talk for about 45 minutes, and then at 8:50, the students will be able to ask questions. They will have to write them into the question and answer link on the page, and I can then read them out and direct them to you.
Sounds good.
Yeah, let's spend some time talking about, we're talking to undergraduates, so let's tell them a little bit about the way the federal court system works. You're a federal district judge. Why don't you fill them in on a little bit of the federal courts, what the federal district court does, how it relates to the others, and just give them an overview in that way.
Well, probably the first misconception that people have about federal courts is, I think people believe that we do a lot more than we do. The state courts handle a lot more cases, a lot more areas of law. There are many, many more state and local laws than there are federal laws. In fact, there are really only 2 types of cases that we hear generally. We are limited in our jurisdiction. The first type of case that we hear is what we call federal question jurisdiction. And that's if Congress writes a statute and then in the statute says the courts of the United States have the jurisdiction to hear lawsuits about this particular issue. In that instance, people can file directly in federal court, and we federal district judges would try the case. The other kind of case is what we call diversity jurisdiction, and that is if all of the parties on the plaintiff side live or are a citizen of a different state than all of the parties on the defendant side, plus the case is worth more than $75,000, then we can hear that case as well. A good example of that, probably the one I get most often, is car accidents. Let's say the large truck hits someone on the interstate. The truck is coming from Indiana going down to Mobile Bay. They hit an Alabama on the road. Because the truck company and the driver are both from Indiana and the victim is from Alabama, and the victim had, let's say, medical expenses of $200,000, we bring that to federal court. And the historic reason for that would be there was and probably still is a fear of, for lack of a better term, homerism in state courts. You don't want elected state judges and state juries hearing cases where their local friend or a local person is suing someone from out of state. The fear was always that the person or the company from out of state won't get a fair shake because the state courts have sort of an inherent bias to protect their own, particularly if a judge is elected by that person and that person's family. Federal courts are shielded from a lot of these political biases because once we're on the bench, we're appointed for life and do not have to run for election. Therefore, it makes sense to allow us to take those cases to protect the interest of out-of-state parties. So really, those are the two types of cases that we hear. If it doesn't fall into a statute that Congress has given us the jurisdiction and it's not a diversity case, the odds are we can't hear it, which is why most cases that get filed end up in your county courthouse and not in your federal courthouse. I'm in a federal courthouse in Northeast Alabama where I am the only district judge, and directly across the street from me is a county courthouse that I believe has either 4 or 5 circuit judges for the county and a handful of district judges, which would all be trial court judges. So there are certainly over there 7 or 8 judges that do what I do on the federal side, essentially by myself for a large area.
And that's interesting. And as a federal district court judge, you in the federal system are the trial judge, correct?
Yes, yeah, we handle all of the trials. When you see most of your confirmations on television, you're going to see sometimes circuit court judges. That is who people appeal to when they don't like our decisions, and obviously the Supreme Court, which is who you appeal to if you don't like the circuit judge's opinion. But we handle all of the trials. I would say that right now, I think I've got 205 civil cases on my docket and over 100 criminal cases. And it sounds very daunting when you first hear the number, and it can be, but obviously all of those cases are at various levels of the procedure. And I think currently our statistics, it's certainly over 95%. I think it's around 98%, both criminal and civil. So while the number sounds huge and it's a big docket, it is mostly manageable.
Yeah, you've answered the next question I was going to ask, which I find interesting, which is how much of your work is civil suits, which involve disputes between individuals? How much is criminal, where it's the state versus an individual? And I guess, how often do you get to actually decide something that touches on a constitutional issue?
Well, I'll answer the first question first, which is civil versus criminal. Like I said, the number of cases is very similar, but I find myself working on civil far more often because criminal cases, like I said, typically will work themselves out where the government and the defendant will reach an agreement where the defendant will plea. In a case like that, the only 2 things that I will do is accept the guilty plea, which takes generally 30 minutes. And then several months later, I will sentence, which is also about a 30-minute proceeding, and then the time that it takes to prep for those. So unless I'm actually in a criminal trial, that is the extent typically of our criminal cases, largely because we have magistrate judges who handle a lot of the, I'm trying to think of the right term, sort of the proceedings that lead up to the trial. They handle a lot of the motions, the preliminary hearings, the initial appearances, at least in our district. So a lot of that burden is taken off of us so that we can focus heavily on the civil. The civil takes up a vast majority of our time. I have a staff of 1 permanent law clerk and 2 temporary. They come on rotating 1-year basis, and they spend nearly the entirety of their time just on civil. I handle the criminal along with my deputy, and the clerks typically handle civil almost exclusively because that's just where the most work is. And the reason it's different is there is a lot of research and writing when it comes to civil cases, particularly for the clerks. For me, a lot of it's being a general manager. It is ensuring that they are getting discovery done on time. It is settling disputes over discovery. It is making sure that this case gets to trial in a much more expedient manner than it would if I wasn't there to make sure it happens. You know, one of the reasons that a lot of people like to go to federal court rather than state is generally we can get cases to trial quicker than the state courts because they're just so overwhelmed with numbers. So one of our goals, certainly in my district, is we try to get cases ready for trial in sort of a 1 to 2 year window. When we set our schedules, it is typically the goal to get it trial ready in about 12 months.
It's interesting now, I see from the information I was given about your background that you've worked on what I think are some really interesting civil cases. So you've been involved with the BP oil spill litigation. You've been involved with the opioid litigation. That's pretty interesting. You want to talk about that a little bit?
Sure. I remember 2010 when the oil spill happened. I was at the time the Solicitor General and didn't really pay much attention to the explosion when it happened and didn't really pay a lot of attention in the 2 or 3 months after that. But I probably should have, because I didn't know at the time that that case would take up 5 years of my time. I transitioned into running the state's litigation against BP and the other responsible parties starting in December of 2010. And I litigated that case until we settled in July of 2015. So for that entire period from 10 to 15, my sole project, my sole case at work was working on the BP oil spill. I traveled to New Orleans on average 50 out of 52 weeks a year because that's where the case was. And got to spend a ton of time dealing with and working hand in hand with not only the federal government, but a group of private plaintiffs attorneys from all over the country. And I don't know how much detail you want to get into how cases like that work, but it was a very large collaborative effort. And by large, I mean they rented several floors in a large building in New Orleans and had people working nearly 24/7 the first 2 years.
Well, to talk about that case a little bit more, I'm assuming that the private attorneys were trying to get compensation for people who'd been injured by the oil spill, and you were representing the state's interest in the litigation. What was the difference or discrepancy between representing the state as opposed to the people who are representing injured plaintiffs?
We had similar and competing interests from time to time. So there were really 3 different groups of plaintiffs. There were the private plaintiffs who would be fishermen, business owners, property owners, people that will go to a private law firm and they will sign them up and file a lawsuit. And there were thousands upon thousands of those. The second category would have been state governments and to a smaller extent county governments within the state who also suffered losses from the spill. Primarily, Alabama's biggest loss was tax revenue. Alabama has 2 counties on the beach that make a significant amount of money in taxes from people coming to the beach. And that is not only county taxes, but the state taxes too. So both the counties and the states lost a significant amount of money on that. So 5 different states had lawsuits in that case. And then the other was the federal government, who had significant environmental penalties. And each one of those types of cases has different laws that apply to it with different standards. So we were all the same in that we were fighting against, and I use fighting loosely in sort of the legal adversarial system sense, but we were fighting against the same group of defendants at the beginning stage to prove the same thing. And that was who was responsible for the rig exploding and for the oil getting to shore. And in that instance, we worked together, and that really lasted from about 2010 to 2013, where we tried the case as far as determining who was liable by percentage in 2013 in New Orleans. Those 3 groups, it was myself, Alabama was the liaison counsel for the state group. So it was us, the federal government, and a group of 16 private attorneys selected by the court sitting at one table, and then law firms representing the 5 major defendants sitting at the other. So you had a huge courtroom full of lawyers for several months. I think the first part of the trial took a little over 2 months, and then the back half of the trial took about 2 to 3 weeks. So it was a very large, and probably something that'd be more interesting is the statistics. There were, I forget the final number, but it was hundreds of millions of pages passed back and forth between the parties. We had a closet at our office that was dedicated to nothing other than hard drives that the defendants would send us full of their documents. And we would just stack them on top of each other. And, after the case was over and we had an order from the court to destroy all of the documents, we were literally left with a closet full of wiped hard drives that, from the government standpoint was like free equipment for us because were much better than what the government would normally buy because we were getting them from private attorneys. So, but it just goes to show you, like I said, there were people who go into private practice, people who are thinking about will know this. There were people on the defense side that I talked to after the case that were billing over 3,000, and I heard some billed over 4,000 hours in a year. And what I mean by that is they were literally on the job doing work somewhere between 3,000 and 4,000 hours a year. And to put that in perspective, if you work a 40-hour work week, 50 out of the 52 weeks, that's only 2,000 hours.
Yeah.
So that means that there were people working somewhere between 60 and 80 hours a week for an entire year. So that was how big that case was and how complex it was. And then I think the settlement itself, it took us about 3 months from the time we started negotiating with BP until we finally announced it. It took about 3 months to get everybody on the same page and just get the paperwork right.
It's pretty interesting. Is it okay if I switch to another big case you worked on, which
Yes.
is opioid litigation? I'd be interested in, can you explain the theory of liability that you were arguing for the people who manufacture the opioids?
I'll do the best I can. The biggest difference between the two cases is the opioid case is still ongoing. Yeah. So opioid manufacturers have not settled with Alabama or the vast majority of states. They have gone to trial against Oklahoma, I believe, and got a verdict. And I think a West Virginia county has had a trial, but that case is still ongoing. I think that the primary case that the states have, let's pick, for example, I'm trying to remember who settled last week, Purdue Pharma.
Yes.
So, for example, the states would have state laws for deceptive trade practices. And that would be, you can't market a product deceptively. You can't sell something without disclosing certain things that you know. So in the instance of somebody like Purdue, you as a state, the sovereign state, would say you violated our deceptive trade practice by failing to disclose to the doctors and or the persons who take it that this particular drug is addictive. And to do so, you would have to prove that they knew it was addictive and in the marketing never told anyone. I think the states, that would be one of your largest claims, and it has penalties attached to it. There are other claims that you can try to seek back the monies lost by the state. The monies lost by the state would typically be things where we've had increased medical cost. We've had increased first responders cost, people having to respond to homes where things have happened, the cost of additional hospitals, et cetera. But from a federal and state government standpoint, potentially the biggest case is more about the deceptive marketing, and the true damage cost is going to be to those persons who got addicted, primarily the families of those who died because of it. So again, it's going to be one of those instances where the government and the private plaintiffs have similar interest in that they're going against the same defendants, but their theories will be different. So you will likely see settlements not by everyone at all at once, but particular groups coming at different times. And unfortunately, that's all I can really say about it, because I know certain things from when I switched over to this job that still aren't public, so I have to be very careful.
I understood. Let me switch gears.
You did ask another question that I never answered because we got off on another topic. You asked what percentage of my civil cases, or how often do I get into constitutional issues?
Sure.
You know, the hot button cases that you see in the Supreme Court does about 75 cases a year. And a handful of those will be the hot button even in the Supreme Court, most of the cases are not the big high priority or the really sexy, for lack of a better term, cases that get all over the news. They're typically resolving conflicts among courts of appeal. When it comes all the way down to my level of court, the trial court level, constitutional issues are very rare. It is a very small percentage of what I do. I think the most recent case that I handled, and I'm still handling, it's still in my court, so I won't get into too many details, but I've got a case of First Amendment protection in political advertising. We had a U.S. Senate candidate in 2017 who there were many articles written about and television commercials written about that he claimed to be defamatory, that helped cost him the election. The defendants are claiming this is protected by the First Amendment. So my job is to apply the standard of the Supreme Court to determine whether or not he can actually file a lawsuit against them at all, or were these commercials protected by the First Amendment. Those are the cases you would typically think about. Those are the ones I think everybody enjoys talking about, but they are more rare than they are common. I think that my most common civil case is employment discrimination. You know, we talked earlier about federal question jurisdiction. When it comes to discrimination based on race, age, gender, etc., disability, those are all federal statutes. So when someone believes that they were passed over for a promotion, they were fired, etc., those come to us. And that would definitely be my number one category of cases that we hear. And again, that changes depending on where you are in the country. You know, certainly the district courts in DC have a much more government-focused, government-related issues than I do. I have a lot more employment. You know, in Alabama, we have less government depending on which district you're in. So it just depends. But certainly the hot button constitutional issues, regardless of which district you're in, make up a smaller portion. I think probably the one in my district now that I did not draw, but it's probably the hottest button, is do state officials have the right to mandate the wearing of masks? Do they have the constitutional ability to limit the number of persons who go to church on Sunday? Can they close restaurants? And if they can, what is the standard and why can they do certain things and not others? So things like that do come up. In Alabama, particularly in the Middle District, we get a lot of voting related cases. We have some of those now. We've got one that has gone up all the way to the Supreme Court and back all the way down to the district level of one of my colleagues recently about voting on sidewalks, curbside voting and other things, but things that obviously happen right before an election. So we do get those as well.
Very interesting. I won't ask you any questions that are about cases that are ongoing. I think it's interesting that you've got a New York Times versus Sullivan case.
I do. I actually have multiple. It's interesting that the same plaintiff, because of where he is from in the state, I've got suits. He ran for Senate in 2017 and 2019. So I have two cases with the same plaintiff on a similar theory, just against different defendants based on which year he was running for office. So, but yes, I have read and learned a lot about New York Times versus Sullivan in the last few months.
Well, First Amendment law is what every law student walks in interested in. And you're getting at least to do that a little bit professionally.
Well, I will tell you that, you know, one of the advantages, and there's no advantage during the COVID era, but one of the things I've been very fortunate about in comparison to a big city like DC is where my courthouse is. It is, I wouldn't say rural, but it's a much smaller city. And I am the only district judge in my courthouse. So we were actually back in the courtroom for smaller civil hearings in late May and early June. So I had a hearing in that case the first week of June that lasted 2 hours. It's exactly what you would think about in a law school class, where you've got people arguing very strongly both sides of the issue of whether or not you can run that commercial or not. So when cases like that come up, they do get very heated, and they are obviously very interesting for those who are watching. But we were fortunate enough to get to actually do that one in person. So,
well, let me switch gears a little bit, and I'll I'll try to take you back to law school and give you a couple of hypotheticals to consider.
Okay.
So what I'll do is I want to pose to you a couple of famous cases that you'll be familiar with, but it will allow you to explain to the students who are watching the way a judge goes about making it, like interpreting a statute or deciding how to come down on one side of an issue. So the first example I'll give you is from the McBoyle case, and I'll read out to the students what the statute was in that case. Right. That was a case in which there was a statute that defined a motor vehicle as, quote, an automobile, automobile truck, automobile wagon, motorcycle, or any other self-propelled vehicle not designed for running on rails. So that was the statute. And the case was about somebody who had stolen an airplane and had brought in, was arrested for an airplane under this statute. And the judge had to decide whether an airplane was covered by this statute as a self-propelled vehicle not designed for running on rails. So if that came to you, how would you go about deciding whether or not an airplane is covered?
Well, I'll do that case first, and then I will say that I have had very similar situations, both when one of my three arguments to the Supreme Court was a very similar statutory interpretation question. And then one of my most recent opinions, one that I think we put out earlier this month, was also a similar, it was an insurance policy, but it's the same issue. You've got a group of words. So the first thing you have to understand is the difference in levels of court. So when you're the district court, you are the very bottom rung. And what that means as far as what you're doing is, the first thing I would do is determine whether or not either the circuit court for my circuit, which is the 11th, or the Supreme Court has answered this question already. If they've already answered the question, there's literally nothing I can do. I am bound to follow what they have said. So if they had already interpreted that case and it came back up, then I would say, because the Supreme Court or 11th Circuit has ruled that airplanes are outside of the statute, then I would have to say it is outside of the statute, see Supreme Court case number 12. And I might be able to say at most, I disagree with it, but they're the boss. But typically as a district court, you wouldn't say that either. You just say this has already been answered by the circuit court or the Supreme Court, and therefore I must follow it. So that's really step one.
What if it's a case of first impression?
Well, those are much more fun.
Yeah.
So, and this really gets into sort of your philosophy of how you're a judge. If you have watched Amy Coney Barrett at all over the last couple of weeks, pretty much anything she said, I would agree with from a standpoint of how you really think. In a case like this, my first job would be to go straight to the statute. And in your instance, the text itself doesn't give a definitive answer, but it gives you clues as to what it's saying. And because I knew this question was coming, I don't want everybody to think that I sleep with this by my side. If the courts above me have not answered it, I have a very handy guide called Reading Law by Antonin Scalia, which is actually a full book of nothing but canons of interpretation. These are ways that he has collected over the years that are proper ways to read certain types of text. And in the instance that we're talking about, where you've got associated words, can you read them again?
Yeah. So a motor vehicle is defined as, quote, an automobile, automobile truck, automobile wagon, motorcycle, or any other self-propelled vehicle not designed for running on rails.
So in that instance, there is an actual canon on point that's called, he calls it the associated words canon. I am not a Latin speaker because I grew up in Alabama, but it's Nocitor Socius. I'm obviously butchering that, but the point of that canon is associated words bear on one another's meaning. That's a summary of the canon. And what that means is if you've got a grouping of words that are similar, then you should read them similarly. And in that group of words that you just read, they obviously are all associated in that they describe automobile, like sort of ground, going across the ground type of machines. That just because something is self-propelled doesn't mean it really fits within that group. And an airplane just isn't really associated by the group. So when you've got a term within a phrase like or other self-propelled vehicle, an airplane just isn't anything like the others. So all of the other words in a group bear on the meaning of the last one. So in that instance, I know because I have gone back and reread the case, the court said that an airplane is not one of the self-propelled vehicles talked about by the legislature in that instance, because it just really has no association with anything else in the statute. That is clearly not what the statute was written to encompass. But again, even though that sounds in a way like you're trying to find the intent of the legislature, you do that without reading any legislative history, reading footnotes. You look solely at the text, and you can tell by what the text says, by the words around it, that this is what the text is getting at. It is getting at different types of automobiles or machines that go across the ground, and clearly airplanes are not it. So that's how I would handle that particular case. If the court above me hasn't said anything on it, and I read the text and it just doesn't plainly answer it, then I try to see what clues I can get from the text, and I have my handy guide that has all of those canons in one place.
I'll ask you one quick follow-up question on
Sure.
this, then I'll pitch you another hypothetical. This was a criminal case, so for this, would the rule of lenity play any role in how you analyze the language?
I don't know, not in the civil case. Well,
This one was criminal.
this was criminal. So yes, it could. And for those who are on the Zoom that don't know what that is, there is a rule that basically says, if you're thinking like baseball, tie goes to the runner. In criminal law, the tie goes to the defendant. If it is not clear which way the answer goes, then you read it on behalf of the defendant, because we want to make sure that the defendant understands or understood at the time of the opinion that what he or she was doing was a crime. If it's not clear from the words of the statute or the criminal code that it's a crime, then we're not going to hold you to a crime that is really a surprise. So that's generally what the rule is. I'd have to go back and read the facts as to that, but I don't know that it would come in, just because I would think that's, to me, that one's a pretty clear-cut case of associated words. So, but just trying to think back, I would assume that that case went towards the defendant anyway, because the plane wouldn't have fit within the wording. So,
The appellate decision was exactly what you just described.
oh, good. So that makes me feel better.
Okay, I'll give you one other hypothetical, and I'll make this a case of first impression, so you don't have to be bound by the 11th Circuit or the Supreme Court.
All right.
It's also derived from a famous case. There was a case, Riggs versus Palmer. That was a grandson who murdered his grandfather. But his grandfather had drafted a valid will. It was a holographic will signed before two witnesses and was legally valid in all respects. And then the grandson claimed that he should inherit under the will. So the question is, can someone who murders his grandfather in order to inherit still collect because the will is legally valid?
All right. So if this is a case of first impression, in other words, there has been no court above me that has answered this question, then the first question that I would ask to the parties is, the one saying that he can't inherit under the will is there any law that was in effect in that jurisdiction when the murder occurred? And if the answer to that is no, then my answer would be, then there's nothing that prevents him from inheriting. Now, I know enough about this case to know that the court in that case went the other way. It's an old New York case. And this one really highlights the difference in sort of constitutional or interpretation philosophy. If you're more of an originalist or a textualist, then the theory would be, and this is what I would subscribe to, as a judge, you are not an elected official. It is not your job to create policy. While in that instance, I would not feel good about allowing this person to inherit money that was ill-gotten. That is really the job of the legislature to write that law that says that you cannot get it. It is not my job as an unelected judge to say that I feel that it would be unfair for him to get it, therefore I won't. So as a district court, typically, and I think in this instance, you would just say, while it may seem to be an unfair outcome, if there is no law that prevents him from doing it, and he, under the law of that state that I'm interpreting, was the proper beneficiary, then I think the answer would almost certainly be that he gets to inherit it. Now, there may be other lawsuits that get filed by other persons later to challenge on some other grounds. But if the question simply is, should I, as a trial court judge, create some exception to the law that prevents him from getting it, I would say that the answer would be no. Again, as a federal court judge, that is because I'm not answerable to the people. I'm not the one who creates the policy. I don't make policy, because if you disagree with my policy, there's nothing you can do to me. You can't vote me out of office. So it is really not my role to be doing that. If that case were to happen and he were able to inherit, the right answer would likely be go to the state capitol and yell and scream and hold up signs, and then hopefully 2 weeks later they pass a law, which of course is what happened in this instance. I don't think in today's world, I don't think that it would be the case in which someone murdered their loved one, obviously to get the benefits, and then they ultimately get it. I think that the law has caught up.
I'll give you a quick follow-up on this, and then we'll move on to something that may be what the students really want to hear, which is about constitutional interpretation. But a quick follow-up on this. In Riggs versus Palmer, the will was legally valid, but this will give you an opportunity maybe explain to students the difference between law and equity, because there was a principle in equity which says no one can profit from his or her own wrong. And that was in conflict with the rule of law. And equity has a legal role in our system. So to the extent that you can explain to students what equity is and what law is and how the dual system works together.
I can. And in fact, I've got an example, and I have to obviously watch the line because it is a case pending before me, so I can't really get into the facts. But for those who don't really know the difference, law is if there is a statute or other rule directly on point, then my job is just to interpret it. Equity, and these two terms come from England. We've adopted the English system, and they had two separate types of courts, the courts of law and the courts of equity. And if the court of law is seen as the one who interprets the statutes that were written by, in the British sense, the Parliament, in the American sense, the Congress, the legislator, courts of equity are more of the judge does what is fair. If the case falls in a court of equity, the court is less bound by law and more bound to do what is quote unquote right or fair in that instance. It doesn't rear its head that often in what I do, but one place where it does, where I'm currently dealing with this issue, I actually have a hearing on this on Friday, is preliminary injunctions and temporary restraining orders. You know, for example, let's say that I'm going to make up one and not use the example I have in court, but let's say that someone sues for copyright infringement and they seek a temporary restraining order or preliminary injunction. What I mean by that is the court has the power to stop you from playing the song or displaying the art until after the trial determines whether or not you have violated the copyright. And when it comes to preliminary injunctions and temporary restraining orders, one of the things that you do as a court is balance the harms between the two parties. And there's no law directly on point on that. It is a total equity decision. How do you feel as the trial court judge that the harms should be balanced in this instance? And at best, the courts above you will say, well, here's sort of a guide or a test you can use. But typically, the district courts have wide discretion to do what they think is the best as far as fairness and balancing the harms to keep. I think the term that the courts use above us is to maintain the status quo pending trial. In other words, how do you protect the defendant from being harmed? In that case, maybe losing business or losing money versus putting the plaintiff completely out of business. Let's say that they've spent money building up a business. The other business says that you stole my trade secrets. How on the one hand do you protect the defendant from losing business to this startup plaintiff, while on the other hand, weigh the interest of the plaintiff who has put in $100 million to build this facility and you're going to shut them down for the year or two it takes to go to trial and they may go bankrupt before the trial. That's the real instance where we have to do an equity judgment. And in all honesty, it can be difficult because in like the hypothetical I'm giving you there, both sides have valid arguments, and you really do have to weigh what the harm to both sides is and try to do the best you can to keep the status quo. And in an instance like that, you really want to try to get the trial sooner than later so that whatever you do doesn't harm one of them significantly before you get there. I will say this, and this is one of the difficult parts about doing that. One of the other factors is not just balancing the harms to each other, but which party do you think has a substantial likelihood of winning?
Right, right.
In other words, if the defendant looks almost certain to win because they truly ripped off, your copyright, the song sounds exactly the same, then the balance of harms is going to go significantly weighed towards the defendant. And the opposite, of course, is true if you don't really believe that the case is going to go the defendant's way. But again, that almost requires you as a judge to in some way prejudge a case before it ultimately gets to a jury who could be the one deciding and not you. So you have to be very careful in that instance not to say too much to prejudge something before it goes. So the equity part is where it gets a little more difficult. To me, the legal part is easier. If you just interpret the statute the way it's written, that is typically an easier question than equity.
Yeah. Well, this is the area in which, as a district court judge, you really have some power. You may not have the power to depart from precedents of the circuit court or the Supreme Court, but you're the finder of fact and you make
Yes.
the initial decisions. And when you use your judgment, the upper level courts won't overrule it unless they think it's clearly erroneous. So this is where you're really doing the work of the law right on the ground level.
It is, and that's particularly important in civil cases. In criminal cases, your job is just basically to be the umpire. It's to make sure that neither side goes too far and the jury hears the case brought fairly. But in civil cases, you have that very important role of writing an opinion, a written opinion in which you determine what the facts are. Now, you can have a jury in a civil case, and they often do, but a lot of times they don't. For example, in the BP case, that was a very lengthy, over 100-page opinion written by that judge who had to determine whose fault it was that the rig blew up and whose fault it was that the oil got to the shore, and assign percentages of fault to the various parties who caused it. And in an instance like that, not only is it important, it is almost never, it is very rarely overturned by the appellate courts. Because like you said, they're looking to see if you're clearly erroneous. And being the judge in the courtroom who hears the witnesses in the box, sees and holds the evidence in certain instances, you just have the ability to determine credibility in a way that appellate courts can't. So typically when you put on paper, this is what I find happened, this is the facts that I found to have occurred and the way I believe they occurred, typically that becomes the case from that point forward. They can argue about legal things that you may have done right or wrong, but typically your opinion on what happened factually, that sticks the whole way through.
Yeah. In a few minutes, I'm going to go to the questions that the students have addressed to us. But before that, in response to an earlier question, you identified your way of interpreting things as synonymous or coincident with Antonin Scalia's. So I'm going to assume that you're an originalist. And the question I'll put to you is, can you explain to the students what an originalist way of reading the Constitution actually means?
Okay, so originalism in Constitution is not much different than when we call someone a textualist on a statute. And the theory is that you should read a legal document, a rule, as it was written and understood by the people who wrote it. And the reason is you should read it that way at the time because that was when it was agreed upon. For example, if somebody wrote a law in 1905, you need to understand what the words meant in 1905 because that was the one moment in history where a majority could come together and come to an agreement that this is what the law needs to be. So it is not up to us to reinterpret in 2020 what we think those words mean. The job would be to rewrite it if we don't agree with what they did. And again, as a judge, it is my job to determine what the text meant when we're talking about the Constitution in the late 18th century or whenever the amendments were written at the time. And if we believe that that is not the correct way or the way we want it to be now, then there's an amendment process to the Constitution, and the people through Congress and then ultimately a vote of the states can amend it. And the same way with a statute, if you don't like what people wrote in 1965, the proper way to change it is not for a judge to read it differently in the way that we understand words to be today. The proper way would be go back to Congress and say this needs to be fixed, and they rewrite a statute. So originalism and textualism are very similar in that the goal is to determine what the law was that the lawmakers passed, because they're the ones who had a meeting of the mind. They're the ones who were elected by the people to pass that law. And if that law needs to be changed or reinterpreted, then the people of today, through their legislature, need to get together and write to change it. It is not the job of an unelected judge who is not accountable to the people to rewrite it by reading it differently than it was written at the time.
Okay, so I'll give you one tough follow-up question to that before I turn to the students. If you're an originalist, what's the role of stare decisis? What's the role of precedent in your reasoning? Because if there's a precedent in between that you think is not interpreting the statute the way it was originally meant, what role do you have with regard to precedent versus the original meaning?
So I have a very easy out to that question. And that out is, as a district court judge, it is totally binding on me. In other words, you can give me any example of a case. And if the Supreme Court has read it in a way that even let's say that I am just a strict originalist judge, and I believe that the Constitution says something about the Second Amendment that is different than the way the Supreme Court said it in Heller, or I don't believe that there are penumbras in the Due Process Clause. That doesn't matter. If the Supreme Court has said it, that is the law. And to me, the district court judge, it is not my job to opine on whether they are right or wrong. It is not my job to say what I would do. My job is to say that that question has been decided. And because the Supreme Court has decided it, I will follow it. And these parties have preserved the right to go up to the Supreme Court and change their mind. So for me, it's a very easy question. When I had to, just like all the justices, had to sit in front of the Judiciary Committee and answer those questions. And for me, every time I would get the question of, do you think that X case is binding precedent? Yes, as a district court judge, I'm bound to follow it, and I will apply it as written. And that was the answer to every one of those questions, because as a district judge, that's what I'm bound to do.
All right, so I'll try to make it a little bit more relevant. What if there aren't Supreme Court or Circuit Court precedents, but your own court has precedents in the past at the district court level that may not be the way you would interpret the original statute? In that case, how do you deal with that level of precedent?
That's the good, harder question. I guess I don't want to answer this in an incorrect way, but first of all, for the students, you are not bound to follow the judges on your own level of court. In other words, there are 8 of us district judges in the Northern District of Alabama. If they've interpreted a statute in a way that I disagree with, I am not bound to follow them. That said, there is something to be said for consistency. There is something to be said for people knowing that when they're in the Northern District of Alabama, this statute means this. And if we, the Northern District, get it wrong, then you can go to the 11th Circuit and they can fix it for all of the districts within. That said, because I'm not bound, if I believe that my colleague is incorrect, then I will write the opinion on the way that I believe the statute is written, and I will openly acknowledge that my colleague has said something different, and I will say, I think this is something that the circuit needs to fix. And I can say that with confidence because I'm working on an opinion now where that's exactly what I'm going to have to do. There's a particular issue of state law that the judges in my district have come to opposite positions on. They have internally not read it the same way. And I feel that my role is to interpret it the way I think is correct, but to call out in the opinion that the judges in my district don't agree with each other on this. And please, circuit court, take this case up and answer it. Even if you answer it differently than me, we need to know what your answer to this is so we can be consistent. So
Okay,
that's a long way to answer your question, but I think that got to the point.
I think it did get to the point. I'm going to turn to the students' questions now. So I'm going to open the question and answer link, and I'll read some of the questions that the students have directed toward you. Give me a moment while I do that. Okay, I'll just read this out. So first, thank you so much for speaking with us, Judge Mays. I have two questions. The first one is, how much do your clerks assist with research and writing? And the second, how do you make sense of legislation that is thousands of pages long? For example, the ACA.
Yeah, I'll answer the first one first. The clerks do, I would even say, the heavy lifting. Typically, when a case comes in, the clerks are the first ones to read the briefs and do the research, and then they will come to me with their recommendation for a ruling on the case. I will look it over, and if I agree with them, then I turn it over to them to write the first draft of the opinion. I become an editor at that point more than the original author. Now, not all cases. There are some cases in which I'll do it from scratch, but 90+% of the time, they're the first ones to read the briefs. They're the first ones to do the research. They're the ones who write the first draft. So they do a significant amount of the work. So if you end up clerking for me, and I know that one of my future clerks is on this Zoom right now, so I know she is listening, when you leave, will see opinions that you can remember writing a significant amount of that opinion because you were the one that did the heavy lifting on it.
Yeah, there's actually another question that's related to this, so I'll give it to you right away. Someone else has asked, any memorable clerkship discoveries? And what he or she is asking is, where a clerk may have changed your perspective on a case.
I will tell you that I don't know about changing. Yes, I talk through particularly close cases. I won't talk just to the clerk that's assigned to the case. I'll get all of us together. I would say most days, there's some point in the day where all of us are sitting in the room together, talking through things. So a lot of times, I don't want to say it's a consensus answer because my answer is the one that ultimately controls, but I certainly will feel better or can have certain parts of it changed. I have certainly changed my mind as I have been editing and writing before. And clerk influence is obviously a big part of that. I will also say that in a case like the one where, I won't go too much into it, but like we talked about earlier, if I've got things where I need to sort of get an understanding of how people might interpret something, I'll just sit them in a room and have them watch it without giving them any information, and I will get their opinion. I mean, the clerks play a pretty big role in what we do internally.
Okay, well, your discussion of the BP case stimulated someone to ask a legally sophisticated question, which was this.
Okay.
Can you explain how the state/plaintiffs attempted to show that the defendants were liable for the oil spill?
Yes, I can absolutely do that. This will probably take 3 to 4 minutes, so I hate to take time. This becomes necessary. So we all filed our original complaints not in the same court. There's something called a judicial panel for multi-district litigation. When you have a case that is big and it spans across the country or across several districts, it is inefficient to force the same defendants to litigate in 50 different federal courts and 150 state courts across the country, because some of us filed in state court, some in federal. There is a group of federal judges who will get together, and there is a statute on point that says, and it has criteria, but when this case has more of a national multi-district, and it would be preferable and expedient to consolidate all of those cases in one location and have one federal district judge handle all the pretrial proceedings, do all of the discovery, make all of the pretrial rulings, essentially what we call get the case in the can, get everything ready to go, put it in the can, and then send it back. BP was like that because you have thousands upon thousands of individuals, plus all of these governments who filed in separate courts, the JPML said, New Orleans is really the epicenter of what happened. So we were all pulled, some of us against our will, some of us willingly, all over to New Orleans. And so that judge has the power to appoint a group of attorneys to represent the thousands of private plaintiffs are represented in this proceeding by 16 people in that case. So the 16 of them, the liaison for the state, which again was us, and a liaison from the federal government worked as a team. And for about 2 to 3 years, we put a coordinated effort to get all of discovery from all of the defendants and came up with a coordinated strategy of what we thought our theory of what happened was. We coordinated on the selection of experts, and we as a team, the 16 private attorneys, the US government, and the state governments went to trial with a coordinated theory of here's why the rig blew up, here's who we think was at fault in certain percentages, and here's why we think it wasn't stopped. So in that instance, there were a lot of nights spent together as a team with people you typically wouldn't work with, but because it was much more efficient to have one, collective theory of what happened, it worked out much better. That was the trial I said earlier that lasted. It took us 2 months to answer the question of whose fault was it that the rig blew up, and it took us 2 to 3 weeks to answer the question of whose fault was it that it got to the shore and wasn't stopped where it was.
And was the basic liability theory negligence?
Yes, negligence and gross negligence. We had argued for punitive damages against BP and Transocean. BP was liable because they leased the land. I don't know if anybody, probably no one has had this. The land underneath the water belongs to the government. 3 miles out, in most states, it belongs to the state government. From 3 miles, I think, to 100, I believe that's right. From 3 miles out to 100, the United States federal government owns the land. And private companies can go to the federal government and seek leases to mine the land under the water. So BP is the owner of that square property where it happened, was liable. Transocean was the rig owner, the rig that was actually that BP had paid to go out and drill. And then there were others who were on the rig doing specific functions. And we had asserted just a simple negligence and gross negligence case against negligence against all the defendants, gross negligence against BP and Transocean.
Okay. Well, I think I've got a question from the person you identified as your future clerk.
Yes.
Because the question is, can you describe what qualities and skills you look for in clerks?
And she knows the answer to this too. So it's interesting. I told her this, and I'll tell the others who answer it. But when you're a federal judge, it is typically seen as the best job to get out of law school. And the truth is, it is. If you can clerk for a federal judge right out of law school, you should do it. It is a great experience, both personally, it's very interesting, and also professionally. It's a great resume builder, and there's no better way to learn to practice than to actually be in chambers and see how it works. See what works well for one side, see what doesn't work, see what strategies are good. So all of that doesn't answer the question. The reason I bring that up is it is very competitive to get federal clerkships. So I would say that every resume I get, and it's close to 100% of the resumes I get, are people who are qualified to do the job. It's very rarely a question, do I think the person could actually do it? So the two things that I really focus on, number one is organizational skills. And it's typically something people don't think about. But if you can show me that you're well organized, that is a huge benefit. And the reason is, like I said earlier, if I've got 200 civil cases and I have to divide that among 3 clerks, you're juggling 60 to 70 cases. I need to know that you can be working on an opinion in one, but watching the things that get filed in 15 different cases on the same day, and that you can keep me apprised of what's going on, because I can't watch all of that at the same time. So I have to trust you that we don't get behind and that we don't miss anything. So if you can show me that you're well organized, that is a huge benefit. And then the other one, quite frankly, is personality. I enjoy having people in chambers that are enjoyable to be around. You know, in Anniston, where my federal courthouse is, we are the only people on that floor. It is 5 of us. It's me, the 3 clerks, and my deputy. And you spend 5 days a week together, you know, 8-hour days, 5 days a week. It is good to have a group that really enjoy being around each other. I take them to lunch, or we go to lunch together at least twice a week, often 3 times a week. Like I said, every day at some point, typically at least twice a day, we're sitting in the room together, talking about cases, talking about law. We also talk about, what are you binging on Netflix? What's the best thing for the judge to watch on Prime? So, you know, you are not only sharing the law together, you're sharing sort of your life and career together too. So we really do value just the fact that we know that you would get along well with the group. So because of that, the way that I interview is, I'll typically bring all of the people we think are qualified in for a first round. And then if there are 2 or 3 that really stand out, we invite them to come in person to the courthouse and spend several hours with us. Come to a hearing, go to lunch, you know, spend good quality time with the whole group and just see what a day is like with us. And we get to see what a day like with you would be as well. So that's really the process that we go through.
Okay, got a couple of questions left. There's one that's going to invite you to give your opinion on current political matters. So I'll give you that one.
Okay.
It is, what do you think about the validity of the left packing the court while the right rushed the appointment of Amy Coney Barrett?
All right. So obviously the stock answer is, I can't get into political issues, and I certainly can't get into issues that could come in front of me. You know, one of the huge benefits of my job is, in comparison to a state court judge, is we're really shielded from the politics. Not only are we shielded from it, we are prevented from doing it. I literally cannot contribute to campaigns. I can't put a yard sign out in front of my yard. I will not talk about who I'm going to vote for. Even if you think you know what I believe or feel, I don't talk about it openly. That is part of being a federal judge, is allowing everyone to understand that you can be fair and balanced. So particularly in an instance like this, where I am talking publicly to a group, it's being recorded, I don't get into issues of left versus right. You know, the general answer to the second question is, the Constitution allows the president to nominate someone anytime there is an opening, and it allows the Senate to advise and consent at any point. So constitutionally, there is certainly nothing wrong with putting Justice Barrett through. Politically, whether they should do it is a question I will not answer, shouldn't answer. But as far as whether it could be done, the answer to that is clearly yes.
Okay.
Well, the answer, by the way, the answer to the other question, because a lot of people may not know this, is the Constitution doesn't say how many justices there needs to be. So it would not have to go to the normal amendment route to change the number of justices. Congress itself could take it up like normal legislation. Now, the question of whether or not you could do so without changing filibuster rules, et cetera, is a difficult one, but then that gets into the politics that I won't get into. But there is nothing in the Constitution that prevents the number from changing. It has changed multiple times in history, just not in the last, I think it's been about 160 years that it's been on 9. So I will say, from a practical standpoint, I don't know where they would put more justices. Having argued in that court, there's not a lot of space for that bench to get bigger. And I don't know if they'd have to build more offices, but certainly the courtroom was made for 9 people, because that's what it was at the time that courthouse was built.
Okay. There's a question that I think is a personal question you may want to answer, and it's just one word. It's the word mentors with a question mark. And I think the question is, did you have any mentors that helped you along?
I think that, as far as, to me, everybody I worked with at the state AG's office, you know, I learned so much by doing. One of the very fortunate things for me was, when I was looking for a job, and this would be sort of my advice for undergrads. I didn't know what I wanted to do out of college. I didn't pick a major till going into my junior year. I didn't have lawyers in the family. My dad was in the military, was a football coach, and then went full-time military. My mom taught. So this was nothing that I had really thought about until halfway through college. But, you know, I really wanted to take a job where I could practice immediately. And I was very fortunate to meet Bill Pryor, who is now the chief judge of my circuit. At the time, he was attorney general of the state. And he told me when I was interviewing with him, you know, I don't have the time or the money to really train you up. I'm going to throw you into the fire on day one and give you your own cases. And that thrilled me at the time because that's really what I wanted to do and learned on the job. So for me, the mentors were all of the people I worked with. BP, for example, I had a partner who is 60, I think he's 64, 65 now. He had worked for the federal government and tried cases for years, and just riding in the car back and forth, talking about old cases and old settlement negotiations and strategies. You just soak it in as best you can. And that's, you know, it's really one of the things that I enjoy about the job I have now, is that I hope that the clerks who come to me straight out of school will get to soak in something positive as well. It's, you know, one of the reasons that we do term clerkships of one. Some judges do two, but I'm going to have two at 1 year every year, so that two new people every year have the experience to come in and do it. And then hopefully they can go out and use that somewhere else.
I've got a question here from one of the students in my class, so I'm definitely going to get it in.
Good.
Just a follow up on what you just said. How many of your clerks get to go on and clerk at the circuit level or the Supreme Court level?
Well, this is only my second year. I took the bench in June of 19. Now, that said, one of my first year clerks is currently clerking in the Fifth Circuit. I'm trying to think of my class this year. I think both of them are going private practice. Next year's group, I have one who's currently clerking on the circuit court and coming to me in the district court. So he flipped it.
Really?
I have one in 22 that that is going to do circuit after she leaves me, and that's already set. So I suspect that the longer I'm in it, you know, the greater the percentage of people who will go and do a circuit afterwards. But I'm just so new to the process that I'm getting into it now. So.
Okay, so my student's got a question for you. It's also kind of a personal question, I guess. He says, thank you for speaking with us, Judge Mays. What's your favorite opinion that you've written and why?
Oh, goodness. I don't know about opinions. It's funny. When I was in school, I thought what I really enjoyed the most is standing up and talking in front of a group of people. It's something that I've always done. I've always enjoyed. I really looked forward to standing in front of juries and talking. It wasn't until I got into practice that I realized I enjoyed the writing. So I don't think that there's a particular opinion that I've written that overall I like the most. It's certain lines and certain phrasings. I really enjoy the phrasing of words and paragraphs. And I know that sounds almost a little geeky, but I do enjoy it. And I will say this, and I know Bailey knows this because she and I have talked about it. I write in a very, what's a good way to say it? A much more conversational tone. I don't mind using contractions. I can start the sentence with the word and. My reading level, it's not that I can't read. I prefer reading more middle-aged school, like Newbery type books. I think Harry Potter is extremely well written. And if I can write an opinion in that sort of style and tone, that makes me happy. So it's not that there's any opinion where I just say, I nailed this one. It makes me happy that I came to this conclusion. It's really when I can go back and read a line and remember coming up with it. You know, several of the briefs I wrote to the Supreme Court, I can remember certain lines and just the thought of coming up with it. I know that in Magwood, my second case, there is the front page. I would even think about spacing on the page. Like, I don't like starting a page in the middle of a paragraph. If I can space it where it starts new, even to that point, I'll do it. But I remember that the introduction was 2 paragraphs, and the second paragraph was one sentence of 5 words. And it was my favorite line of the whole. It was the whole point of the case was whether someone had waited too long to make an argument and whether they should interpret a statute to say that you only get one bite at the apple. And the first paragraph was like 4 or 5 sentences talking through the first time this person had been in court and all of the years and all the arguments he made. And then the second paragraph literally was just, that was 34 years ago, period. But that was my entire case in 5 words. And it just, that sentence, and because it fell at the bottom of the page and it just sat there and it was like what you saw on the front page, that was what stuck out. So I know that may sound deep, but that's the part I enjoy about writing. It's the really thinking about how do I encapsulate my argument. Or in your undergrad, if you're going to write a paper, how can you really get it down to one small thing and just get right to the point in a pithy sort of way that just sticks out? And if you can do that, you have succeeded.
I look forward to teaching your opinions from casebooks someday.
I hope I get some that are worthy of doing so.
It sounds like your writing style is Oliver Wendell Holmes's writing style. He's just got a couple of one sentence, that's it. That's all I need.
I enjoy that. I find it easier to read. As I remember when I was practicing, I preferred reading people that wrote that way because it was just easier to digest. And I always thought that if and when I get to do this, I'm going to write in a way that someone reading the newspaper, if I've got an opinion that I think is going to get in the newspaper, I want a person who didn't go to law school to understand what I'm talking about.
Well, all future law students will thank you for that.
Good. I hope so.
We're almost at time, so I'm going to invite David to come back on and wrap things up. But first, I'm going to thank you for a really interesting conversation and for sharing your time with all of us here at Georgetown.
Very good.
All right. Well, thank you, Judge Mays, for coming out tonight. And thank you, Professor Hasnas, for an excellent, wonderful event. And just to close it out on a more lighter note, material was really light. I really enjoyed it. It was so easy to comprehend and everything.
Good.
But just to close it out in a true Alabama fashion. And, this was one of the questions. Judge Mays, Roll Tide or War Eagle?
I am an Auburn grad. My parents were Auburn grads before me. So anyone who doesn't like the University of Alabama is okay with me. And I know Bailey now is upset because she is a Bama grad. So that's too bad. I am Auburn through and through, which unfortunately means I have to understand a lot of pain and mediocrity from time to time. So it's not an easy thing being an Auburn fan, but it really toughens you up and gets you prepared for the world.
All right. Well, thank you so much for coming out tonight, Judge Mays.
Thank you. It's good to be here.